Agora tenho a honra de anunciar o capitão John Pearn, mestre em Direito Ambiental e bacharel em Gestão Portuária pela Academia Marítima Lloyds. O capitão de longo curso, John Pearn, em 1992, iniciou a praticagem em Milford Haven, Inglaterra. Atual presidente da Praticagem de Milford Haven, onde foi prático instrutor por 5 anos. É vice-presidente da Associação de Práticos do Reino Unido, do qual foi membro do Comitê Executivo por 8 anos. Ele falará sobre a regulação inadequada e suas consequências, trazendo o exemplo do Reino Unido.
Thank you very much for that introduction. Unfortunately, I didn't understand it, so I hope it was nice. First of all, I'd like to extend a big thank you to Ricardo, Ottavio, Marcelo and Flavia for putting on a 5-star conference in a 5-star facility from a 5-star organisation, which are the Conapra, the Brazilian pilots. Like all good pilots, I won't take a vessel where I know it shouldn't go. So, based on the age of the last presenter, I'm not going to comment on my age. However, I will take exception with Joe Angelo's comment that Ottavio is the best looking pilot in the world. I've been told it is me, and like all good pilots, I never disagree with my mother. Okay. Should have done a risk assessment. There we go. My career started in 1979. I was an apprentice pilot in Liverpool in the United Kingdom. After completing my apprenticeship, I then went to sea on a variety of ships, and my last voyage was from Rio de Janeiro, exporting fruit to Antarctica, because they don't grow much fruit in Antarctica. After I got my master's licence, I then became a pilot in October 1992 in the port of Milford Haven in the United Kingdom. Today, I would like to look at the legislation of pilotage in the United Kingdom from the perspective of an accident. The accident I will look at is that of the Sea Empress, an oil tanker which grounded with catastrophic effect in 1996. I would like to explain the consequences of the accident, primarily so that you can appreciate how the effect of such an accident can affect a wide variety of people and stakeholders. I will then look at the legislation that was in place at the time of the incident, and also the legislation that has developed since. Okay, this is the port of Milford Haven. As you can see on the bottom left-hand side of the chart, you can see 2 buoys. That is the entrance to the port of Milford Haven. On the 15th of February 1996, the Sea Empress was booked to berth at 2000 hours, just before low water at the Texaco oil refinery, which was 6 miles inside the entrance. As the vessel approached the entrance buoys of the port, she experienced a strong, unexpected set to starboard. The helmsman reported a loss of steering. Almost immediately, a strong vibration was felt by everybody on board, and the ship developed a heel of 21 degrees to starboard. The smell of crude oil was noticeable to all on board. The vessel's engines were immediately put astern, and she was brought up to 2 anchors within a mile. Also, she grounded further on in the entrance as well. The initial grounding actually caused only minimal damage. Less than about 1,000 tons, I believe, which is still a considerable amount. Because apart from one cargo tank, the number one cargo tank on the starboard side, the main damage was to the segregated ballast tank, which had been ruptured, and this had caused the sudden inrush of water, which increased the draft from 15.7 metres to 21 metres. The problem with that was the increase in draft meant that the options for moving the vessel were very limited. At that draft, she was unable to go further into the port, and to go out of the port away from danger was only a very small, because they were neat tides, it was only a very small gap to get back out. The subsequent salvage operation caused 72,000 tonnes of cargo to be discharged, which was tremendous consequences for all concerned. It was nearly a week before the vessel could be brought into port and the navigational channel could be cleared. Many ships were left stranded inside the port because they couldn't get out, and many ships were stuck outside the port with cargo for the refineries and they couldn't get in. Also, there were severe consequences for many of the other port users. Now I'd like to discuss some of the consequences for the personnel involved. We must not be allowed to think that an accident is simply an academic concept, or a political consideration, or a theoretical concept. Real people, both those involved in the accident and those who are totally innocent, can have their lives devastated. And in the most serious cases, as we've just learned today in Genoa, 10 people have lost their lives. Sorry, go back there. Yeah. Immediately after the accident, there is normally intense media coverage. The newspapers and television will follow all the protagonists. They will camp outside the houses. They will follow the pilot, the harbour master. They will follow his family, trying to secure exclusive interviews. They will use bribery, blackmail, anything to get an exclusive to get on the news. The media attention doesn't go away just after the accident. It reappears when the investigation is announced, the results of the investigation are announced, when the court case comes up, the result of the court case, and quite often the anniversary of the incident. You'll also find that whenever there's other incidents, they want to come and speak to the protagonist to get their point of view. Obviously, after any accident, there's an investigation. In the United Kingdom, the Marine Accident Investigation Branch conducted an independent investigation. The conclusion was that there was pilot error, poor bridge team management, poor relationship between the pilots and the port, and serious administrative problems with the port's management of the pilots. We've also, there's bound to be disciplinary, there's blame. Quite often, a port authority or a regulator, in an effort to deflect criticism from themselves, would publicly seek to discipline the people involved, in this case the pilot. He was put through an investigation. He was told in no uncertain terms, do not bring a lawyer because you'll be found guilty. And as it happened, he defended himself with the support of his colleagues. And the disciplinary action that was brought against him under the 87 Pilotage Act tried to convict him of either incompetence or negligence. He was able to, with the support of his colleagues, he was able to defend himself against these charges. But the legal cost, and we're talking 17 years ago now, for both parties was probably near $500,000, and that was just a disciplinary internal investigation. The personal stress upon the protagonists and their families should not be underestimated. Many of the people involved received anonymous threats through telephone calls, through the post. Some of them, up to 15 years after the incident, people were still receiving anonymous threats along the lines of, we know where you live, we know where your family goes to school, if anything happens, we're coming to get you. So many of the people, specifically the pilots and the harbour master, have required many degrees of police protection, surveillance and investigation. This doesn't make the news, unfortunately. Okay, the consequences for the port. UK authorities, through the Environmental Agency, undertook a thorough investigation of all aspects of the incident. Upon the conclusion of their investigations, no charges were brought against the pilot. However, they chose to prosecute the Port Authority and the Harbour Master. The charges brought against Milford Haven Port Authority were under the Water Resources Act 1991, which creates a legal concept of strict liability. Effectively, there is no defence. The Port Authority had no option but to plead guilty, and they suffered a fine of £4 million. Please bear in mind this was 17 years ago. This was subsequently reduced upon appeal because the Port Authority could then demonstrate they had reacted to many of the criticisms and they had a much more robust and stringent operating procedure. Fortunately for the Harbour Master, charges against him were dropped. The port also had to deal with its stakeholders, the refineries. Milford Haven had at the time 3 oil refineries. They also had a fishing fleet, a ferry terminal and a small general cargo terminal. Many of these people, the fishermen, local leisure boat owners, all sought compensation from the Port Authority, specifically after they had been found criminally guilty. Milford Haven itself is based in a national park. I don't know, some of you may have been to Milford Haven. It's in a very beautiful part of southwest Wales. It relies heavily on tourism. Now, initially after the incident, which happened unfortunately in the winter, the hotels in the area received lots of business. The press, the media, the investigators, people just coming to have a look. However, once the pictures of oil on the beach got into the media, all the bookings for the summer holidays disappeared. And the beach went from one of people surfing, swimming, to the picture you see there of people cleaning up oil off the beach. This was the impression the rest of the country had now of Milford Haven. Milford Haven was also an important fishing port. Many of the fishing fleets from Belgium, France and Spain land their fish in that port because it's close to the Atlantic fishing grounds. However, after the incident, they didn't want their catches to be connected with this Milford Haven area, and so many of them took their business elsewhere. Local fishermen could no longer make a living. They were actually, the area immediately surrounding the entrance was closed for fishing for 3 months. Lobster and crab fishing was stopped for a further 6 months after that. This had a dreadful effect on many of the small operators, and many of which went out of business. Also, it's probably more famous, is the consequences for the environment. Over half her cargo was spilt from a position within a mile of the coast. The immediate outcome was a large-scale clean-up. Even so, 15,000 tonnes of emulsion washed up over 200 kilometres of the coastline. As a result of the major clean-up operation and natural dispersion, as I said, it was in the winter, very bad weather, by the end of the summer, there was only 500 tonnes left unaccounted for. At the height of the response, more than 50 vessels, 19 aircraft, and 25 organisations were directly involved. This involved 250 personnel at sea and 950 personnel ashore. The disposal of the waste material itself was a major difficulty, and the total cost was expected to exceed, on conservative estimates, of £60 million. This figure does not reflect the financial impact of tourism or commercial fisheries, which can be measured in further tens of millions. Once again, I remind you, this happened 17 years ago. The cost today would be far more. I could go on for hours talking about the contributory factors in the Cyprus, but today I'm going to concentrate on the legislation, the regulatory factors that were in place at the time. Okay. First of all, I should talk about the change in legislation prior to the Siempress. Since I've come to Brazil, I find there's some remarkable parallels with what's happened, what is being considered now for Brazilian pilots and what happened to the UK pilots in 1987. In the United Kingdom, records of pilotage stem from those developed in the 12th century, long before Brazil was a figment of anybody's imagination. The inhabitants of the island of Oloron in France have developed a system for pilotage. In those days, if a pilot lost his ship, his penalty was to be taken to the windlass and to have his head cut off. Human rights intervened, fortunately, and this punishment was reduced to being hung from the mast. By 1514, King Henry VIII, who's famous for having 6 wives, formed a guild called Trinity House. And for the next 450 years, this guild, together with a number of local pilotage commissions, maintained the standards of pilotage in the UK. With very few exceptions, the majority of the pilots were self-employed. They worked privately or within cooperatives for the port. Following intense political lobbying from commercial interests, principally port authorities and shipping industry, in 1987, the government introduced the Pilotage Act. This transferred responsibility from Trinity House and local pilotage commissioners to the direct control of the commercial ports. With the effect is, today, the UK does not have a national pilotage legislation. It has somewhere of around 70 different pilotage organisations. All ports are independent from each other and act in an independent capacity. Many of them are in competition with each other. For example, on the Thames, we've got Medway, London and Felixstowe, all major container ports. All borderland the pilotage is in the same area. These ports are in direct competition with each other, and part of that port structure involves the cost of pilotage. So the ports obviously see pilotage now as a cost centre. The main economic driver of ports is to make a profit. Since 1987, ports consider the pilotage as an income stream rather than a service to be provided. This focus on profits has the effect it distracts from developments in ship types and trades, which may require adaptations of pilotage provision and training. An example of this is the introduction of double bottoms and segregated ballast. The last presenter made a good demonstration of it, saying what a very good development it was, and it is a very good development. However, the unintended consequence is that certain vessels are physically larger than their deadweights would suggest. Due to the introduction of double bottoms and segregated ballast tanks, we are no longer in a position to ascertain a vessel's size purely on its deadweight. In the port of Milford Haven, traditionally the pilots were assigned to vessels based on net tonnage. After they became employed in 1987, this practice was changed to deadweight. This had the unforeseen consequence of changing the Siempress from a vessel which required a first-class pilot and an assistant, which was restricted only to entering the port 2 hours before high water, to only requiring a second-class pilot and also allowing the vessel to enter that port at any time. Investigations made after the incident showed conclusively that a vessel of that size had never previously entered the port at that tidal state, which was an hour or so before low water. It's more to do with the direction of the tidal flow at the entrance rather than any depth constraints. Following the incident, various options were considered over how to remove this difficulty, and it was found that the simplest solution was to work on gross tonnage. Consequently, in Milford Haven now, every vessel over 65,000 gross tonnes is considered to be a VLCC, requiring 2 pilots with restricted entry time. Also, they have to have escort towage. Sea Empress was 77,500 gross tonnes. Coincidentally, Milford Haven is now the major importer in North Europe of LNG. We now handle Q-Max and Q-Flex ships up to 345 metres long. Because of that, the port has changed the way it also charges ships from deadweight to gross tonnage, conveniently increasing its income stream from pilotage. The legal response after the case came from Lord Justice Steele. In summing up the case on the prosecution of Milford Haven Port Authority, he made the following statement. Ship owners and masters must engage a pilot. They have to take the training, expertise and experience of the pilot provided at face value. He then went on to say, the Port Authority imposes a charge for pilotage, but in the same breath has the added advantage of the pilot being treated for purposes of civil liability as an employee of the ship owner. All this calls for the highest possible standards on the part of the Port Authority. Credit has to be given to Milford Haven Port Authority in the way they responded to that judgment. They took on board the judge's comments, subjected themselves to many management studies, and they took on board a lot of the criticism that they received. And their administration of pilotage has developed to take into account the lessons learned. For example, pilot progression is now more stringent. It takes 5.5 years to progress from trainee to first class pilot. This is based on gross tonnage classes as previously explained. Previously it took 3 years. No pilot can now progress to the next class of vessel until every other pilot in that port has signed him off to say that he's happy to progress. There is a stringent, robust training standards been brought into place. This involves a 1-week simulator course between each class before you get promoted. You do a man model course at the beginning of your pilotage career, then after your first class you do a refresher every 5 years. We do escort towage training every 2 years on a simulator. We've done marine resource managers courses. We have done ECTIS courses. We all are issued with the PPU. And for first class pilots, there is a robust system of continual professional development. And I have to say that if we go to our Port Authority and we feel there's a justification for a training programme, we can convince them, then we get it. Additionally, escort towage is now compulsory for all LNGs, VLCCs, as well as smaller vessels which use black oil. The Port of Milford Haven is very highly regarded in the way it runs pilotage and safety management systems, and we frequently receive visitors from all over the world to view our operations, particularly with regard to our LNG trade. We could say it's a shame they never learned the lesson before the accident. It would have been a lot cheaper. I'll now contrast that with the regulatory developments in the UK. As a result of the Sea Empress, the United Kingdom's Department for Transport developed the Port Marine Safety Code. This code establishes the principle of a national standard for every aspect of port marine safety and aims to enhance safety for those who use or work in ports. It applies to port marine operations, the well-established principles of risk assessment, safety management systems. It provides a measure by which harbour authorities can be accountable for legal powers and duties that they have to run the harbours safely and to help to discharge their obligations effectively. It is an excellent document, it's very thorough, however it has one major flaw. Due to commercial pressure from port authorities, it is not compulsory, they're simply guidelines. It's a bit like, I don't know if you've seen Pirates of the Caribbean, the code of conduct for pilots. They're not so much a code as guidelines. Some ports, however, has to be said, are very diligent in adhering to its requirements. Other ports choose to comply with only certain sections, and some pay very scant regard to it at all. Ports, on their part, are required to write to the regulator, that being the Maritime Coast Guard Agency, every 3 years to declare that they comply with the Port Marine Safety Code. That's their only obligation. Remarkably, some 60% of the UK ports do not even bother to write that one letter every 3 years. The Coast Guard, unfortunately, doesn't have the resources, nor it would appear the inclination to police the code. The ports are very much left to inspect each other. Some of them do invite a local port to inspect them, in return they expect them. In response to certain criticism, the ports developed the Guide to Good Practice. This is intended to supplement the Port Marine Safety Code and contains useful information and more detailed guidance on a number of issues relevant to the harbour authorities. It contains general guidance of how a harbour authority should meet its commitments in terms of compliance with the code. To avoid any confusion, on its introductory page it has this most helpful advice. Like the code, this guide does not have any legal force. Clearly, the message to the ports are loud and clear there. The Department of Transport, for their part, has declared it would like to see national occupational standards for pilots. The UK pilots work very closely with the port associations to develop national occupational standards. Not surprisingly, these standards which the Port Association have helped to develop are appended to the Port Marine Safety Code, and as I can remind you, they are not mandatory. So therefore, Port Association tasked with introducing these standards, not surprisingly, they remain on the shelf and for the most part are not being applied. Many UK pilots are faced with competent harbour authorities that only do the bare minimum of pilot training based on a cost argument. While the UK pilots have traditionally been recruited from master mariners, there is actually no national requirement to set any entry standards. Each port is allowed to set its own standards. As I explained, each port is effectively its own independent pilotage authority. One major port operator owns 21 ports in the UK. In one port, it requires a master mariner's qualification. That's the port of Southampton. In the Humber, which is one of the largest ports in Britain, its advert for pilots recruitment simply states recent seagoing experience and the right to reside in the UK, which could mean anybody from the 27 European Union countries. And another port, Cardiff in South East Wales, it is currently attempting to train a pilot boat coxswain over a period of about 6 months. So he's expected to gain the experience and judgment that would come from somebody who previously would have a master's certificate. Not particularly adequate, we don't think, and it's something we are bringing to the attention of the authorities regularly. The latest blow to pilotage came less than 2 weeks ago. The United Kingdom already enjoys one of the most liberal pilotage exemption regimes. Under the Pilotage Act of 1987, any bona fide master or mate of a vessel is allowed to apply for a pilot exemption certificate if his vessel regularly visits the port. That means generally it's small coastal vessels. Once they've done half a dozen trips in and out, they'll have an examination and they will be exempt just for that vessel. Due to European working time regulations, seafarers now have their working time constrained. So rather than take a pilot to guide their ship through the most perilous parts of its voyage, through congested pilotage waters with strong currents and rocks and heavy traffic, they've successfully lobbied for a change in the law. So as of 2 weeks ago, any deck officer can now have the conduct of their ship in pilotage waters. In conclusion, The United Kingdom's government port policy is driven by the commercial lobby through the British Ports Association, UK Major Ports Group and the Chamber of Shipping. Their prime motivation is profit, with concerns for safety and environmental protection being very much secondary. Just like to summarise where I've got to. Port authorities should be very careful when developing regulations for pilotage systems. The primary purpose of pilotage is the safety of shipping and the protection of ports and environment. Any legislation regarding pilotage should ensure that this remains the principal purpose. Poor regulations in themselves do not make poor operators, but they do allow poor operators to function. The provision and regulation of pilotage should not be subjected to commercial pressure. Regulation focused on the commercial aspects of pilotage can be detrimental to the best interests of safety and efficient pilotage. If you believe that provision of a robust and efficient pilot service is expensive, consider the cost of an accident. To the person, not only in financial terms, but to the personal lives of the people involved, to the port and its customers, to the local economy, to the coastal environment, and not least of all, to the reputation and credibility of those that were seen to allow the accident to happen. And that could easily come back on the regulators or the legislators. High standards and effective training prevents accidents. Cutting costs does not. The provision of highly trained maritime pilots who are allowed to use their skill and experience independently, free from commercial pressure, is the best safeguard you can give to the infrastructure of your ports and coastal environment. Accidents do not just happen to other people. I was the pilot on the Sea Empress. Nobody goes to work looking to have an accident, and nobody deliberately creates legislation to reduce safety. Ineffective legislation can have the unintended consequences of creating an environment where the focus of operation and services providers is drawn away from safety. In his opening address, Ricardo asked, "Why are we not yet a developed nation?" I suggest you have an advantage. You can learn from our mistakes rather than repeat them. Thank you very much for your attention.